The sources of Malaysian legal system are from two different laws, the written and unwritten law. This video will be looking at unwritten law. We hope by the end of the lesson, learners can achieve the following learning outcomes. Let us look at the definition of unwritten law. The word unwritten law is defined by various authors. However, it can be simplified as unwritten rules, principles and norms that have the effect and force of law, though they have not been formally enacted by the government. There are three sources of unwritten law: English law, custom, and case law. We will now look at English law. English law is part of Malaysian law. After the forming of the Federation of Malaya on 1st of February 1948, the Civil Law Ordinance 1956 or CLO was developed to replace prior legislation. The ordinance specifies the application of English law. English law was introduced informally and indirectly through the residential system, where English law consists of common law, principle of equity, and English statute. Due to the non-uniformity of the development of English law in the Malay states, there are three separate statutes on the application of English law. However, after the formation of Malaysia, the CLO 1956 was extended to Sabah and Sarawak. Today, the Civil Law Act 1956 is the current statutory authority. The extent of application of the English common law is stated in Section 3, 5, and 6 of the said Act. Section 3, subsection 1 lays down the application of English law. The section provides that in the absence of written law, the Malaysian court shall apply the common law and rules of equity in England. On the following dates: 7th April 1956 in West Malaysia, 1st December 1951 in Sabah, and 12th December 1949 in Sarawak. However, the application of English law is subjected to the following circumstances. 1. Absence of local legislation. It must be proven that there is a lacuna or gaps in the Malaysian legislation for English law to be applied. The qualification is illustrated in the case Attorney General Malaysia versus Manjit Singh Dillon. 2. Cut-off dates. Only common law and rules of equity existing in England on date specified in Section 3, subsection 1 of the Civil Law Act can be applied to fill in the local law's lacuna. Any subsequent development in English authority after the date is not embodied. This can be seen in the case Lee Ki Chung versus 4 Nombor Ekor Sendirian Berhad and others. Third, suitability with the local circumstances, or we call it as local proviso. English law is applicable only if local circumstances and inhabitants permit. This can be seen in the case United Malayan Banking Corporation versus Pemungut Hasil Tanah Kota Tinggi. Section 5 of the Civil Law Act provides English law application in commercial matters such as banking, partnership, insurance, and many more. The exclusion of English law is stated in Section 6, where it excludes the application on matters concerning land tenure. This is because the local legislation incorporated the torrent system, an Australian system of land administration. Customary law. Most law originates from ancient custom. Likewise, in Malaysia, the melting pot, we have developed our laws from various customs. According to Curzon and Smith, the word custom refers to a long-standing practice. Hence, there is no customary law of general application. The customary law that still survives to this day are the following: the Malay customary law, natives and orang asli customary law, and the Hindu and Chinese customary law. The Malay adat or custom commonly divided into two, adat pepatih and adat temanggung. Adat pepatih is characterized as democratic and organized matrilineally, while conversely, the adat temanggung is characterized as aristocratic and autocratic and organized patrilineally. The Hindu and Chinese customary law are brought in by the settlers and recognized by England's law. However, today, with the introduction of the Law Reform Marriage and Divorce Act 1976, have diminished the relevancy of Hindu and Chinese customary law on marriage divorce. This can be seen in the case Chu Ang Chi versus Neo Chan Neo. The application of customary law in Sabah and Sarawak is more extensive and systematic. Before the British arrived, the fundamental law for the Malay in Sabah was presumed Sharia law, and the non-Muslim is the native customary law or general application. Meanwhile, there is a well-established system of unwritten customary law in Sarawak and was preserved during the Brooke administration in Sarawak. Judicial decision. The law in Malaysia is not found only in legislation, but in cases decided by the courts. The courts here refer to the superior courts. Only the decisions of superior courts are sources of law. Judicial decisions are made by judges on written and unwritten law on relevant issues in actual cases before them. Precedent means something that precedes or comes before. Hence, the judicial decision is a law source where past decision of the judges creates law for future judges to follow. There are two types of precedent, binding and persuasive precedent. Binding precedent is where a court is bound to follow its prior or past decision or decision of a court of the same level. This is called the doctrine of binding precedent. Persuasive precedents are precedents which local superior courts borrowed from other Commonwealth countries with similar laws. The precedents are persuasive. However, if it is being adopted, the decision will bind the lower courts in Malaysia. To understand more about binding precedent, let us look at the hierarchy of courts. The doctrine of binding precedent is where a court is bound to follow its prior or past decision or of a court's decision of the same level or equal jurisdiction. The doctrine works in two directions. Vertical, meaning top down. The lower courts are bound to follow decision of the courts above it. For example, if there is a decision made by the federal courts, the courts under federal court has to follow the decision that has been made. Horizontal means the high courts are bound by prior decision of the courts of the same level. For example, a decision made by High Court of Malaya, it will bind other high courts in Malaya and Sabah and Sarawak. So basically, the precedent is to promote certainty of the law.